All right, we are live and on the record.
Great.
Hear
Thank
ye,
you very
hear ye,
much.
hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Thank you. Good morning. Welcome to the Appeals Court. My name is Justice Desmond. Your panel today is Justice Sachs and Justice Shin. The first matter that we'll be hearing today is Brad Hoyt and others versus J.C. Madigan Incorporated and others, docket 19P1517. We've read your materials, so you can get right to the heart of your arguments, and we'll begin with the appellant counsel, Attorney Hurley.
Good morning, Your Honors. I am Attorney Edmund Hurley, representing the two defendants, appellants, LR Properties, LLC, the landlord, and J.C. Madigan, Inc., the former employer of Brad Hoyt, one of the plaintiffs being the family. I ask that the court consider three primary categories of issues in addressing whether or not a new trial should be granted to the defendants in this case. First, the issue of Dr. Johnson's 180-degree change in his opinion, Dr. Johnson being the plaintiff's medical expert at trial. Second category being the improper information that the jury heard, including that a prior tenant alleged she had cancer and that the plaintiff's counsel referred to litigation stress, which is admittedly a non-compensable category of damages. And then finally, the 93A order, where the trial court doubled the damages. I would like to correct one error in my reply brief. At page 20, I did reference the Boston Edison Company case versus Mass Water Resources, which is a 2011 SJC case. And the plaintiffs had referenced that to address the standard on a new trial. That case does reference in a footnote, I believe it's footnote 5, the issue of a new trial, and that if there is a new trial, that it might be limited by the court to issues that were erroneously addressed. However, that case did not have applicability or any analysis of the new trial matter in any depth. For new trials, I would refer the court to the Fife versus Mass Bay Transportation case, a 2014 appeals court case that does address new trials and is on point. Concerning Dr. Thomas Johnson, who was both a treating physician for all four of the plaintiffs and was the trial expert, he was deposed. He submitted written disclosures as to his opinions. The defendants filed a motion to preclude him under Daubert and Lanigan, and also had asked the court to supplement that motion, and there was the motion in limine hearing. In February of 2018, the trial was in May of 2018, Dr. Thomas Johnson signed an affidavit, and he confirmed that he had found authoritative certain learned treatises.
So I think we understand that when trial came, he said some of those same sources were outdated and that he didn't rely on them in putting together his opinion. My question is, was there a contemporaneous objection made to his testimony on that basis? That he was doing a 180, as you say, from what had been disclosed?
No, Your Honor, I don't believe there was, other than the motion in limine under section 103 of the Massachusetts Guide to Evidence, Part B. It does refer to a party failing to object to the admission at trial, but that the rights with respect to the admission may be preserved if it was raised in a motion in limine and the motion was heard and denied.
But what issue was raised in the motion in limine? It was to preclude him from testifying at all, wasn't it? It wasn't to preclude
Yes,
him
Your Honor.
from, it wasn't to preclude him from disavowing or characterizing as outdated the articles that he'd relied on in his affidavit. So that issue wasn't raised in the motion as far as I could see.
The obviously the defendants desired and sought to preclude him entirely, but the lesser sanction of him limiting his ability, I believe, was implicit, and that it's not just a Daubert and Lanigan issue. It goes to the issue of disclosure, because it's not enough for a witness, an expert witness, to disclose various opinions and then on the eve of trial have an affidavit which purportedly narrows it down, but then somehow to change it created an unfair situation for the defendants and their expert.
So toward that point, was there a specific objection regarding the disclosures?
I believe that there was, but only in the motion in limine in the Daubert Lanigan hearing.
Was there also a document that he referenced or spoke to at trial that was not contained in his affidavit, an article?
Yes, Your Honor. The witness had referred to an article that was repeatedly identified as the Zhang article. Dr. Zhang was the primary author of that article, Z-H-A-N-G. The article was written, published, I should say, in December of 2016. But the substance of Dr. Tom Johnson's disclosures, that is the plaintiff's experts, were all written in the summer of 2016 before that article. The trial judge improperly let that article be referenced. It wasn't an actual exhibit, but it was repeatedly referenced under the statement that the defendant's expert, Dr. Aceta, had said there is no authority linking asthma to mold. And the trial judge improperly permitted the reference to the Zhang article because the suggestion was that the Zhang article did make a causal connection, but in fact, the Zhang article only referenced an association, and it was, as I said, written late in 2016. So that was an example of an unfairness where the defendant's expert did not have sufficient time to review that article, which did rely substantially on animal studies as well as studies on people. The defendant's proposed expert, Dr. John Galpe, a medical doctor and psychiatrist, was not permitted to testify, and more importantly, he was not permitted to examine the plaintiff with the most ailments, although not all related to mold. But Maria Conversano had arthritis that did substantially contribute to her anxiety. Ms. Maria Conversano, the plaintiff, had a history of psychiatric issues, which were severe. The fact that she didn't reference anything beyond so-called garden variety emotional distress at trial shouldn't have prevented the defendants from at least examining her and having Dr. Galpe write a report. Even potentially, it might not be admissible, but where she had certain self-destructive behaviors and other ailments and other life issues, it posed an improper burden on the defendants and prevented evidence from getting to the jury. On the other hand, evidence that did go to the jury that was improper included the reference to litigation stress. This was brought to the attention of the judge immediately after the plaintiff's closing argument, and the judge at sidebar essentially dismissed it and interpreted what the attorneys said as being something else.
But did you ask for a curative instruction? Did you ask the judge to tell the jury that damages for the stress of litigation are not available and they shouldn't consider that?
No, Your Honor, I don't believe that that was done. However, there was a factual issue, and that is that the court basically said that there wasn't an argument appealing to litigation stress. And so, unfortunately, I thought my ears deceived me. But it's clear from looking at the transcript that it was the case that the plaintiff's attorney referred explicitly to 4 years of litigation and referred to the harassment and one of the daughters having to leave the courtroom during the matter.
Would that issue be relevant to the willfulness or knowingness of the 93A violation?
I don't believe that the litigation stress itself would be relevant to the 93A, but a key case cited by the judge in the 93A was the Cruise Management versus Thomas case, a 1994 case, where the trial court mistakenly awarded no 93A damages, and the SJC basically said you must, and it was just attorney's fees. Here, the trial judge in our case said that where it's willful and knowing, I must at least double the damages. But that's an inaccurate statement of law. And we know that because of the Cruise Management case itself, which is a 25-year-old case that has a lot of cases following it. In Cruise Management, not only there was specifically 18 months from 1989, early 1989 to late 1990, where the court found that the landlord had not only rats and a defective fire, electrical issues, but specifically an absence of a needed fire emergency exit. Clearly, the landlord had to, with something that physical, had to have either known or should have known of that safety defect. But nonetheless, it was just attorney's fees awarded in 93A, despite that willful and knowing violation. Although any one of these errors may not have been enough to create the need for a new trial, in combination, along with what did appear to be a bias in favor of the plaintiff, specifically with helping him and how to word questions and whatnot.
Can I ask about the bias? Is there any specific ruling or finding that you contend was affected by the bias, or anything that the jury saw that was affected by the bias?
Well, the first thing, the 93A, I think, was affected because I know the judge did say that the defendants contested everything. The judge did not say that in front of the jury, but he said it orally in oral argument at 93A. And then I believe he did, in awarding attorney's fees, he did say that in writing at some point in awarding the plaintiff's attorney's fees. In terms of what the judge saw, what the jury saw, not only did the judge at sidebar say things, but eventually the judge said in front of the jury, "Counsel, I told you that your questions should not center on opinions, but rather should concentrate on facts." And that was said both at sidebar and in front of the jury, so that where the jury can see the court assisting one side, there is naturally the creation of a subtle bias that was unfair to the defendants.
And your position is because he slightly reprimanded or corrected counsel, that was when the jury saw the bias? Is there any other instance that the jury may have been aware of any comments that the judge made to counsel?
The bias that the jury saw was really not directly from the judge, but when the judge at sidebar would tell the plaintiff's attorney how to form questions, then the jury was seeing that which a better case, where the defense didn't have that coaching, so that was unfair, and clearly the jury saw the improved questions from the plaintiff's lawyer.
Was the issue of bias raised at any time before the trial judge?
No, Your Honor, except, no, Your Honor, period.
Thank you. I see that's your time. Attorney Connor.
Your Honors, may it please the court, John Connor for the appellees. First,
Perhaps you could pick up where your brother left off. What do you say with respect to the bias argument?
I think a reading of the entire transcript shows that the judge was quite even-handed. He did, I think, fulfill his duty to get a coherent case to the jury by nudging each side along in certain areas. Certainly suggestions were made to plaintiff's counsel as to how he might streamline his questions so that it's more coherent. Most, if not all of that, was outside the hearing of the jury at sidebar and at conferences. But the same was true for the defense. There was several instances where the defense benefited from the suggestions of the judge. One particular case, Ms. Megas, who was a witness as to the notice, which was a central issue in the case, the notice to the landlords of the adverse conditions. At one point, a sidebar was had where the judge essentially pointed out to defense counsel that he was digging a hole, if you will, because the witness's testimony was unfavorable and the question seemed to be unfavorable. That was certainly favorable to the defense to point that out to them. Certainly plaintiff's counsel would have preferred that line of questioning to continue if it was unhelpful to the defense's case. But the totality of the view, if you look at the entire transcript, the judge was quite even-handed. There's no instances of any bias, and I think that if there was a helpful hand, it went both ways. The judge was simply trying to fulfill his role, as he should have, to make sure that the case gets to the jury in an efficient and understandable way. Trial judges regularly will nudge one side or the other in a way that makes that happen, and I think that's all that really happened here. There's no indication of any inherent bias on the part of the judge or favoritism from one side to the other. So I'd suggest that that's certainly not an issue that would warrant a reversal in this case in and of itself. If I could speak to my brother's argument regarding the disclosure, first and foremost, the standard that this court must review a judge's decision to allow in expert testimony if an issue is raised as to the scope of the disclosure or the inadequate disclosure is that of abuse of discretion. The question is whether the judge abused his discretion under the circumstances of this case to allow in that testimony. We suggest in our brief, and we've tried to go to some pains to demonstrate this to the court, that if you look at the disclosures and you look carefully at the voir dire testimony and you look at the trial testimony, there was no substantial deviation in the testimony before the court compared.
That's really not the standard, is it? Because since there was no objection raised at trial to the admission of the expert testimony, I think it's too late to argue abuse of discretion. Aren't we under the motion for new trial umbrella, which would require the defendants to show a miscarriage of justice?
Well, if in fact that's true, that the record does not support that an objection was preserved, I would agree with that it would be a miscarriage of justice standard. But even under that standard, If you look at the disclosures and the testimony, there's no substantial variation, nothing that the defense can really say they were surprised to the point where they could not prepare or could not adequately cross-examine. The reference to the Zhang study came up far earlier than trial. It was a subject matter of deposition testimony some months earlier. So this was not a new or novel study that the defense never had an opportunity to review, as they've suggested. And it's simply one study that the expert testified that he relied on as part of the basis for his opinion, specifically regarding the connection of asthma to a patient who is not otherwise allergic to mold. So the study stood for the proposition that you don't have to have an allergy to mold necessarily to ultimately have an asthmatic response to exposure to high levels of mold. But it wasn't the only study. The doctor specifically testified in his voir dire that it was the most recent study. And in fact, in cross-examination, the defense expert admitted specifically that the Zhang study was not the only study, that there were other studies. And I would direct your attention specifically to volume 3 of the appendix, page 384 specifically, where the expert admits on cross-examination that there are studies, yes. And those studies he references are not just Zhang, but other studies. So the defense expert acknowledged that he was aware of studies making that very type of link. So the claim that they are somehow prejudiced by the citing of this one study, when in fact the expert acknowledged knowledge of that area of study isn't supported. In terms of the mention of improper information, the one reference that a witness made spontaneously to having had cancer, the judge effectively cured that. He immediately gave a curative instruction to the jury. The jury is presumed to have listened and followed the judge's instruction. And the evidence that came in this case was overwhelming in terms of the impact on this family. And for that one reference that was subject to a curative instruction to be the basis for prejudicial error, I would suggest gives far too much weight to the one reference and overlooks the effect of the curative instruction. The reference to the argument that the closing arguments contain reference to litigation stress, I would suggest that the statements made by counsel were vague at best. He certainly never said to the jury that they ought to be compensated for all they've had to go through at this trial or through depositions or anything remotely that specific. We agree that there is no damages for litigation stress, but the jury was instructed specifically by the judge on what the appropriate elements of damages were. And nowhere in that instruction was the jury instructed that they could consider litigation stress as the basis for an award. I'd suggest that the jury got it right in this case. The awards were commensurate with the evidence. They didn't seem inflated or the product of some emotion or bias. They were relatively modest when you consider what the plaintiff's case was, when you consider what the plaintiff was asserting, or all of the plaintiffs. Particularly Ms. Conversano, she was asserting that she had suffered a very disabling condition as a result of her exposure. The expert testimony was that she was 100% disabled as a result of the aggravation of her underlying pre-existing arthritis. The jury award did not reflect the jury's belief that that evidence was entirely supported. It was a much more modest verdict than you might expect if they believed that evidence. So if counsel did make statements that were beyond the scope of what he should have, or by somehow implying or suggesting litigation stress, it did not appear to have influenced the outcome for this jury.
At the close of the closing arguments, did the judge ask to meet with the lawyers regarding excuse me, following his jury instructions, did the judge ask to meet with the lawyers regarding the instructions themselves and whether or not they were satisfied?
Yes, there was a charge conference. The judge did ask the both counsel if they were satisfied, and both counsel indicated on the record that they were satisfied. I would suggest that the 93A award, the doubling of the underlying judgments in this case, is well supported by the evidence. The judge made detailed findings, detailed factual findings. There were serious code violations. I think that is undisputed in this case. There was certainly allegations of serious harm, and the jury believed that at least some of what was alleged actually occurred. And there was ample evidence that the landlords in this case had a great deal of notice. Many years earlier, prior to our client's tenancy, they had notice of these specific conditions and did very little to address them or to look further into the potential ill health effects that might result from this condition. And a landlord's failure to act under those circumstances is a clear violation of several of the sanitary codes, which were introduced into evidence and the jury was instructed on, and certainly formulate the basis for the judge's decision. So I'd suggest that there's nothing about the 93A findings, the application of law to those findings, or the ultimate conclusion of the judge that would warrant reversal. In my remaining time, I would like to just address briefly one of the arguments made in the Dalbert hearing, and I would suggest that the judge most certainly fulfilled his duty as a gatekeeper in this case to allow in the testimony. He held a hearing in which Dr. Johnson testified to his vast clinical experience, his subspecialty in particular in mold exposure and his interest therein. He testified that he is familiar and has familiar with the scientific data in that field, that he has a vast library of scientific data, and he testified that he relied not only on his clinical experience, but both skin prick testing, which is a standard form of testing in his area, serological testing, review of each plaintiff's medical history, his workup of each plaintiff, and ultimately his knowledge of the science in this area and particular studies. On that basis, I'd suggest, and certainly the case of Hicks that we cited in our brief supports this conclusion, he cannot be said to have abused his discretion in terms of fulfilling his function as a gatekeeper. This evidence was certainly contested. The defendants had a full and fair opportunity to present their own corresponding or conflicting expert testimony. The expert was subjected to rigorous cross-examination. So under all of those circumstances, it's our position that the judge fulfilled his duty properly, that evidence was properly admitted, and that the jury verdict should not be disturbed based upon that. As the courts have said, simply because there may be a difference in the views or maybe even a minority view that's entered into evidence, we shouldn't be fearful that the jury can't handle the science behind that. The jury had a significant amount of science they had to consider in this case, and both parties had a full and fair opportunity to put that before the jury. I suggest there's no basis to overturn this verdict, that it was a case that frankly went in fairly for both sides, and we believe the jury got it right and the jury verdict should not be disturbed. Thank you.
Thank you, sir. Any additional questions from the panel? Hearing none, you do have 1 minute and 45 seconds left if you'd like to use that time, Attorney Connor. Otherwise, we'll consider the matter submitted.
Well, I'll make one last point. My brother did argue in regard to the judge's denial of the motion to have a psychological evaluation performed on one of the plaintiffs. We've argued it in the brief, and I won't belabor the point. but there was no evidence that her psychological, any serious psychological issue was ever put before the jury in this case. In fact, I think the judge was quite careful to assure that that did not happen, particularly in one area of cross-examination from the defense. So this is, in fact, a garden variety emotional distress claim, and it was appropriate for the judge to limit that inquiry from the defense. Thank you.
Thank you. I think we understand both positions.